to our series Lawyers, a byproduct of our YouTube channel The Normal Litigators. I'm Advocate Upasna, Legal Associate at the Law Offices of VIVEK Tanwar, Advocate and Associates. Today going to let you know about the concept of living will. The concept of living will is new and many people have certain ambiguities about it. So we have bring for you our podcast episode. A living will is a written statement in which a person expresses his desire as to which medical treatment is to be chosen in future circumstances where he or she will not be able to express the consent regarding it. Therefore, the living will is also called as advance medical directive. Now the question arises as to which legal formalities do we have to comply while making a legal will. First of all, one should be an adult, that is 18 years of age or above. And secondly, while making a living will, you should be of sound mind, capable of taking decisions as well as able to understand them. And the third point which you have to remember is that the decision to make the living will should be completely voluntary. That means it should be free of consent. Fourthly, you remember to write the details in your living will in a clear way. They should be specific, detailed as to what option the authorized person has to choose in respect of your medical treatment when you are not able to give the consent. The fifth point which you have to take in consideration is about the instructions on revocation of living will. You have the authority to revoke the living will at any time before the situation comes when you are no longer able to give the consent. You can also include any other instructions which you want to give about revocation of will. Sixthly, about the declaration. You have to declare that you are well versed with the contents of the living will, that you have understood all the consequences of making this will, and the living will is made with free consent. Lastly, do not forget to specify the name of the guardian or any close relative who shall be authorized to take decision on your behalf at the relevant time. The person shall be responsible to give consent for specific medical treatment or withdraw the consent if you have expressed desire against the medical treatment. Therefore, make a wise choice while choosing such person. Now we will discuss about the registration process. The registration process of living will is slightly complicated than that of our regular will. But you don't have to worry, we have short it down in a simple manner. Firstly, the living will has to be signed by the person who is making the will in presence of two witnesses. And the living will has to be countersigned by the judicial magistrate first class. Then, the judicial magistrate first class further assure that the living will is executed voluntarily or without any coercion or under influence by the witnesses. And one of the copy of living will shall be preserved with the JMFC, one in Registry of Jurisdictional District Court. One copy will be given to the respective municipality or municipal corporation or panchayat if required. Then, the judicial magistrate first class will make your family members aware about the fact that you have executed such document. After it, the judicial magistrate first class will hand over one copy of your living will to the family physician. Now the question is, how to implement the living will? When a person who has made the living will is terminally ill and going through a prolonged medical treatment where there is no hope of recovery, then one has to make the treating physician aware about the advance directive or living will so created by the said person who is terminally ill. Then the physician has to ascertain the genuineness of the document from the office of the JMFC before acting on it. The advance directive will be implemented only after ascertaining that the particular illness is incurable or the patient is undergoing prolonged treatment or is surviving on the life support. After it, the hospital where the patient is being treated will form a medical board, and that medical board shall form an opinion as to certify or not to certify the instructions made by the testator in the living will and will inform the same to the family of the testator. After it, Once the hospital certifies the instructions made in the living will or advance directive, the hospital will inform the same to the jurisdictional collector. The collector shall constitute another medical board consisting of Chief District Medical Officer. Then, the chairman of this board will convey the decision of the board to the jurisdictional JMFC before withdrawing any medical treatment. The JMFC shall visit the patient as early as possible, and after examining all the aspects will authorize the implementation of the decision given by the board. And the thing that is to be noticed here is that if you have made more than one living will or advance directive, then the most recent one will be considered as valid. That's all for today. I hope you all have liked our podcast channel. If so, then do please subscribe our channel Noble Litigators. Thank you and have a good day.